So about how many people have entered?
Got 14 computers in now.
Okay. That's better than the recent attendance in some of my classes.
All right, everyone, we're going to get started in just a minute. We're just waiting to see if some more folks join us. Maybe wait one more minute and then go ahead and get started. All right, everyone. I think we'll go ahead and get started so we can be respectful of everyone's time. Thank you so much to everyone for joining us this evening for New Thinking on Jacob Henry. I am Kara Dedman. I am the curator of the North Carolina State Capitol, and I'm actually joining you from my office in the Capitol building in downtown Raleigh. We are the 1840 Capitol, home to the North Carolina General Assembly from 1840 until 1961. The building today is a North Carolina State Historic Site. So if you haven't been to the Capitol and you are able, please come visit us sometime. The building is open to the public Monday through Friday, 9 to 5, and Saturday, 10 to 5. And we'd love to see you. And though we are the historic Capitol, we're still the active capital of the state of North Carolina, as we still serve as the office of the governor. So this evening, we are joined by legal scholar Seth Barrett Tillman, and Seth will be discussing Jacob Henry, our state's first Jewish legislator, and the legal and historical questions posed by his service in a Protestants-only North Carolina General Assembly. So on December 6, 1809, in the first state house to stand here on Union Square in Raleigh, Jacob Henry delivered a speech about religious liberty to our legislature. And Henry represented Carteret County during a time in which people were bound constitutionally to affirm the, quote, truth of the Protestant religion before holding any public office. So tonight, Seth will be talking about the story of Henry, the standard narrative of Jacob Henry, and his time in the assembly, and then how that narrative has been misunderstood by historians and other academics. So Seth Barrett Tillman is an internationally recognized legal scholar. And although he is currently right at this very moment joining us from Ireland, where he teaches, he was born and educated in the United States. He holds degrees from the University of Chicago and from Harvard Law School, and he has clerked for the U.S. Court of Appeals, the Third Circuit, and judges in the United States District Courts in Alabama, Pennsylvania, and New Jersey. He taught constitutional law and as an adjunct, at Rutgers University School of Law, Newark. Currently, Seth is an associate professor at the Maynooth University School of Law and Criminology. His work on Jacob Henry has been published in the North Carolina Historical Review, as well as the American Journal of Legal History. So I will now hand this over to Seth.
Hello. Kara, thanks for that warm introduction. I'll say it again for anyone who just came in. I'm speaking to you from Ireland. I've lived and worked and taught here in Ireland for about 11 years now, but I'm an American, so you won't hear much of an Irish accent. I was only recently promoted to associate professor here, hooray. And I've done a couple of things before coming here. Kara's mentioned some of them. I clerked for several federal judges. I taught as an adjunct in an American law school. I have some degrees from 2 American universities. And for reasons that I'll make clear, I found myself publishing on Jacob Henry, an interesting figure from North Carolina history. Though I can't say that at the end of this talk, you're going to agree with everything in the standard narrative about Jacob Henry that Kara put forward. Part of my work has been to destabilize that narrative. Let me tell you a little bit about Jacob Henry, a little more than Kara told you from the standard sources. We're not exactly sure we know when Jacob Henry was born. Most historians suggest it was 1774, 1775. We're not exactly sure where he was born. Some think North Carolina, some think South Carolina, some just admit they don't know. It appears that shortly after he was born, the family migrated from South Carolina to North Carolina. By around 1790, Henry was still, below the age of majority, but we do know from a census from that year that his family owned some slaves. His parents were living in Carteret County at the time. Subsequent to that, when Henry became an adult, he continued to own slaves. According to the standard history, Henry was Jewish, but we don't have really a lot of information illustrating that well. We have some information pointing to the fact that his father or stepfather was Jewish. We have some information pointing to the fact that his mother was Jewish. His mother was buried in a Jewish cemetery in Charleston. We think he was buried there too, but we don't really know. What we really don't have are any affirmative statements from Henry that he was Jewish. And in his celebrated speech in 1809, his speech in his own defense so that he wouldn't lose his legislative seat, he spoke in very elliptical terms. He certainly never said in clear terms that he was Jewish. And either did the people who objected to his membership. So all we can really say is he probably was Jewish. There was a Jacob Henry that at around 1820, around the time Henry left North Carolina and migrated back, or at least to South Carolina, was a member of the main Jewish congregation in South Carolina, in Charleston. We think it's the same person, but again, we don't really know. In any event, the political story of Jacob Henry starts in 1808. At that time, under the 1776 Constitution of North Carolina, legislative service in both houses, the lower house and the upper house, was for a 1-year term of service. Henry was elected in 1808, and he served that term without any, eventful political consequences. In 1809, he was elected to a second term in the lower legislative house, and the legislature met for that second term in November 20th. Apparently, he was sworn in, though that's a little unclear. There were no objections at the time he was sworn in, and for several days, the legislature continued to meet. Henry, as Kara mentioned, was from Carteret County. He was from the county seat of Beaufort. On December 5th, things began to change. There was another member, his name is Hugh C. Mills from Rockingham County, and he objected to Henry sitting as a member. Now, Mills made 2 related objections to Henry sitting as a member, but Mills didn't say in any, express terms, I'm objecting because Henry was Jewish. He objected on the basis that somehow Henry wasn't qualified, or he didn't take the qualification oath in the correct way. Most people have understood that to mean, though it's very unclear what it did mean, that Henry either didn't take the oath, or perhaps he wasn't holding a Christian Bible, or perhaps he wasn't holding any book at all, or perhaps he was holding a Jewish Bible. That's the way it's been understood, but we don't really have Mills around to ask. Another objection that Mills made was that he couldn't qualify. And both of these objections seem to be wrapped or tied to Article 32 of the Revolutionary Constitution, which, as Kara mentioned, limited holding office to people who do not deny the being of God or the truth of the Protestant religion. And whether that limitation extended to legislative positions is in fact what attracted me to this inquiry. So a little bit about me now. How did I come to study this? I usually write on legal issues, and the legal issue I've been exploring for the last 10 or 12 years has been the use of the word office and officer in the US Constitution. And as part of that project, for over the last several years, I've looked to how federal statutes and state constitutions and state statutes have used the word office and officer. So that's how I came across the Jacob Henry story. That's what led me to it, so to speak. Again, some have understood this objection of Mill's, this Article 32 objection, to be rooted in the fact that Henry was Jewish and therefore in some way not eligible. And others have understood his objection as Henry had in some fashion failed to take the qualification oath, or both. The funny thing is, after Mills objected, the next day, the legislature, the lower house of the legislature, meant to adjudicate this motion, spent basically the whole legislative day, and decided not to agree to the objection. As a matter of fact, we have some indication that the vote to reject Mills's resolution was in fact unanimous. But the funny thing that happened afterwards is that the records with Jacob Henry grow dark. What we do know is around 1820, he migrated. And that means, and we also know that between 1809 and 1820, Henry didn't run for political office again. And there's very little record in South Carolina or North Carolina what Henry did. Apparently, when Henry went to South Carolina, he joined a local Federalist militia and became its secretary. So another thing Henry apparently liked a lot was guns. He died in 1847. There's a funeral notice in a newspaper in Charleston. It doesn't say he was Jewish. And as a matter of fact, there was no obituary, which is kind of odd because even during his life, his speech was fairly well known and reproduced in books for young people studying elocution, studying American legal principles, or at least general constitutional principles about tolerance and toleration. But Henry seems to have fallen, Henry the person seems to have fallen out of the picture. So again, what caught my interest, at least initially what brought me to this, was this use of the word officer in the 1776 Constitution, because in evaluating the Henry story, many people have made the argument that the reason Henry didn't lose his seat was because the language of office and officer in the North Carolina Constitution did not extend to seats in the legislature. That might sound a little counterintuitive, but if you look at the language of the North Carolina Constitution, you'll see that when the drafters of that document wanted to refer to legislative seats, they would use the language of member or members. When they wanted to refer to positions in the executive or judicial branch, they tended to use the word officer. I'm not suggesting that was the reason Henry in fact prevailed. As a matter of fact, I think that we have found, and I have found, documents that have purported that that argument was made, but that's not necessarily the reason he prevailed. The other reason people have suggested Henry prevailed was because of his speech and arguments using similar principles. That is, Henry made a famous speech in his own defense, tied to principles of toleration, equality, fair play, religious freedom. And of course, those principles were rooted in the North Carolina Constitution. The Declaration of Rights at the beginning of it talked about freedom of religion. So that's another reason Henry might have prevailed. But again, the funny thing about those two theories is that we don't really have an indication, at least contemporaneous indications from the members of the legislature, why they voted the way they did. So one of the oddities we have with the Henry story is later discussions after Henry's life, antebellum discussions and postbellum discussions, discussions that are about general US history, discussions about North Carolina history, discussions about Southern regional history, or church state history, and even discussions about Jewish history. There are a lot of people who purport to explain the reason why Henry prevailed. Some of them think it related to the use of office and officer, and therefore it didn't apply to members of the legislature at all. And some people think it was because of these broad principles of religious freedom and religious toleration. You have these two rival explanations, and the proponents of one of these explanations are often completely unaware that other people do not accept that explanation, but have a different explanation. And the people who put forward one of these, a single explanation, often are completely unembarrassed in not having any sources for suggesting that's the reason Henry prevailed. At best, what they could put forward is some early sources suggesting that these arguments were made, which is really a very different thing entirely. And I have to say, this is much like what I found in my own field, which is that it is not uncommon in law and legal history to find that over a long period of time, any number of sources citing one another, any number of commentators will make bold claims about why something happened and really can't point to primary documents or to contemporaneous documents bearing out their theory. And that led me to thinking that it might be time to re-examine and look again for the primary documents. Unfortunately, there aren't many to look at. What we have from the state legislature in their records is very bare bones. It just describes the motion practice of Mills's motion to exclude Henry. It indicates that there was debate, and then it indicates the debate was shifted to the committee of the whole. And then it indicates that a vote was taken and Henry prevailed. But it's very bare bones because in those days, legislatures didn't record debate. We are differently placed today from earlier investigators in that we now have these platforms which record and reproduce early American newspapers. Of course, there were collections on fiche to do so, but they're hard to research. So what I decided to do is to look to see if there were newspaper articles contemporaneous with the Henry episode that recorded the debate. And perhaps one of the mistakes I did not make that other people made before me was that I realized that a newspaper isn't going to occupy an entire issue with lengthy debate. And I looked after the events of 1805 and 1806, that I looked in later issues in late December, January, and February. And in fact, some debate can be found. Perhaps not a complete debate, but some debate. And that opens up for our understanding other possibilities of what really happened or what did happen at the Henry debate. It's not going to prove why the members voted as they did. It will simply tell us more of the arguments that were in fact made. And as I said earlier, one of the interesting things about these reports is that there's some indication that Henry prevailed unanimously, which would even seem to indicate that the parties who made Mills, who made the motion to have Henry excluded, either didn't participate or had changed his mind, which is a very surprising result. Another interesting thing about the standard narrative of the Henry debate is that most people understand the motion to exclude Henry by Mills as, at least in part, that Mills was objecting that Henry didn't take the oath of office. Or if he didn't take it, he didn't take it in the right way. Perhaps many people have understood it to mean that Henry refused or didn't hold a Christian Bible. But one of the strange things about that debate, and even stranger than the other narrative I describe among the historians, is that if you read any of these sources trying to explain Mills's objection related to Henry's oath, they never show you the oath. That is, if someone was talking about a member of the United States Congress and said he didn't take the oath, what we'd expect to see would be in the text, they'd reproduce the oath that a member is expected to take. But the commentators, and there are any number of them, and I don't mean just recent commentators, I mean going back until the early 19th century, who say Henry didn't take the oath, or Henry didn't take the Christian oath, or Henry didn't take the Protestant oath. They never show you what the oath was. They not only don't quote it, they don't even tell you where it is in the North Carolina Constitution or in North Carolina's collected statutes. And again, that's something that seemed to me to call for an exploration, a re-examination of the early documents. And finally, another thing that historians often disagree about is how frequently was Article 32 enforced? That is, some historians suggest that the Henry episode was the first time, or perhaps even the only time it was enforced. Others say it was the first time in the legislature, as if it had been enforced in other ways, and others say it had been enforced infrequently. But again, none of these historians point to or explain how they made that determination, or other episodes where the limitation on holding office was enforced. So I'll mention a few other examples of where historians and other commentators have made bold or very odd statements about the Henry episode. And one of the and to say they made bold or odd statements is odd, in part because we know so little and have so few primary documents from which to understand these events. A historian in 1931 described the Henry episode as a prolonged contest. Prolonged. The motion was made on December 5th. It was debated on December 6th, and that was the end of it. Another more recent historian and commentator, John Meacham, writing in a book called American Gospel, characterized the Henry incident as a standoff. Again, it was adjudicated over the course of one legislative day. Jacob Rader Marcus, who's one of the leading historians of American Jewish history, not now alive, earlier commentator. He described Henry as writing his speech after consulting with eminent Christian jurists. But there's no record of that. There is a record of Henry consulting, perhaps, with one such jurist, Judge Taylor, who later became Chief Justice Taylor. For some reason, Marcus expands upon that and says it uses the plural. There's no evidence of that. And John Meacham described the Henry contest as a contest between Henry and Christian lawmakers. But again, that's just a very odd way to describe the event, especially because there's every indication to believe when it was finally decided, it was unanimous on Henry's side. So describing it as a contest or between Henry, the perhaps lone Jewish member, and Christian lawmakers is a very, very odd way to describe these events. So all these disagreements come to us absent citations to primary and contemporaneous sources. And again, that's what led me to look for new information and for new sources from which we could tease or figure some of this out. I've already mentioned that there were two primary arguments that were made at the time and that have been developed in literature: the office argument and the more ambitious arguments that were developed in Henry's speech. And I've already mentioned the fact that I've turned to newspaper articles. I will mention that at the time I found these newspaper articles, I thought I was the first to uncover them. I was wrong about that. It turned out that it was an archivist in North Carolina who, as part of a course requirement in advanced history, wrote a paper for her class and put that manuscript on file with the State Archives in 1984, where it sat for many years unnoticed to the world. And I don't think this archivist really understood how novel and how new the information was that she found. Leonard Rogoff found that manuscript. He's sort of the dean of North Carolina Jewish history, and he wrote about at least one of those documents in his book, Down Home Jewish Life in North Carolina in 2010. But I have to say, as much as admirable as Rogoff's book is, and as his uncovering this document before me, I don't think he quite saw how that one document, along with others, really destabilized the standard narrative. Let me just tell you a little bit about what's in those new documents. First, there is some development of the office argument. Gaston, who later became a justice in the North Carolina Supreme Court and was one of Henry's contemporaries in the legislature that year in 1809, in fact, made that argument. but it's not exactly what carried the day. And we also know that not only did Henry give his speech, but there were others in the legislature who, in support of Henry, made arguments along the lines of toleration, equality, and freedom of religion. As a matter of fact, one member in very strong terms said, we can't investigate people's religion. That would make us a court of inquisition. And he, the speaker, said, I certainly won't do that. None of us should either. But neither of those arguments really carried the day in the legislature. And we know that because after those arguments were made, instead of ending the proceedings and having a vote in Henry's favor, the proceedings were transferred from the legislature as a whole to what's called the Committee of the Whole, where the legislative house meets as a committee. The result of meeting as a Committee of the Whole means that the speaker is no longer in the chair and that the committee appoints a new chair. And the new chair of the committee was General Thomas Love, who was a very colorful figure from early North Carolina history. He participated in the Indian Wars. He fought against the independence of what was called the state of Franklin, where western counties in North Carolina not only tried to break away from North Carolina, but apparently tried to set up their own independent country. And he led to their being reintegrated into North Carolina, that is, those western counties. And as a matter of fact, he eventually, towards the end of his life, emigrated from North Carolina to what was becoming the new state of Tennessee and became Speaker of the House there. So when the Committee of the Whole met, they heard from the Clerk of the House, and they heard from 4 members, including one state senator. The state senator, I think, was a friend of Henry's. He was a state senator from Carteret County that Henry was from, and one of the other members was probably a member from Carteret County also. And that makes sense because these people probably would have known Henry being from the same county. Now, when one reads the report of what these people testified to, because that's what the Committee of the Whole looked at. Before it went to the Committee of the Whole, people made abstract legal arguments, but the Committee of the Whole wasn't hearing legal argument. They were hearing testimony. They were hearing facts, what people saw, what people heard with regard to Henry. And the first thing that strikes you is that Henry didn't testify in his own behalf. He gave a speech on his own behalf in very abstract language at the beginning of the proceedings, but he never testified. And the various witnesses were asked questions about Henry. They were asked, did they know his religion? And nobody seemed to know his religion. They asked if he ever denied the truth of the Protestant religion or the Christian Bible, and nobody seemed to have ever heard him deny anything. They never saw him in synagogue, which isn't surprising because there weren't any synagogues in North Carolina until after the Civil War. They asked what book he took his oath on, and nobody could quite see it. One member said he thought his stepfather was Jewish, and he understood, that was his language, he understood that Henry was Jewish, but this member said he never heard Henry say so. One member was asked if Henry ate pork, and the response was, I don't know. Another member suggested that what Henry did is he had a traditional Christian Bible, but he divided it, with the implication being he divided it between the traditional Jewish canon and the Christian one. But nobody was certain of anything. As a matter of fact, it's a little bit of an overstatement, but it really had the flavor of a Sergeant Schultz effect. I know nothing. Nobody seemed to know Henry in any detailed way. Nobody seemed to know the truth of what he did when he swore it. And this might be an alternative explanation, to why the committee and why the assembly voted as it did. That is, it could have been the office explanation, which was the explanation that initially attracted me to study this event. I certainly would have liked that. It could have been that, and it could have been part of that. And it also could have been Henry's speech relating to tolerance and principles of fair play and equality. It could have been that. We don't know. But it also could have been that the testimony, the facts that were brought before the Committee of the Whole they were very unclear, and they were conflicting. And in other words, given that Henry had a procedurally regular election, and given that the standard of Article 32 was you had to deny, not just not believe, you had to deny the truth of the Protestant religion, and there doesn't seem to be anything in the record saying he did that, the simplest way to deal with the Henry matter was for the members to simply say, well, we haven't heard any facts that he denied it, and to simply push the whole matter overboard. It might have been that was what persuaded many of the members, or perhaps even a majority of them, among the unanimous or near unanimous group that was for vacating the motion. That puts the Henry motion in a very different light than does the standard literature. That is perhaps, if that's true, it illustrates that the membership was probably very uncomfortable with this proceeding. They found it unusual, something that they didn't gladly go to investigate, that they felt, I won't say forced, but they had to investigate it once Mills raised the motion. They were constitutionally committed to do so. But they weren't exactly ambitious about it, and they weren't conducting a religious crusade or anything like an auto de fe. Once the evidence was put in front of them, they said it just doesn't reach the bar, and they kicked it all overboard. And it doesn't appear to have been on partisan lines. So even though Mills was a Jeffersonian Republican, and even though Henry was a Federalist, it appears that everyone pretty much, perhaps everyone, voted for Henry. So it doesn't look like it was really on partisan grounds. As a matter of fact, I happen to think that probably it was not only Henry's political career that ended in 1809, it was also Mills's. We never hear from Mills again after this legislative term ended. He seems to have disappeared from the political record. And I don't think that's all that surprising. I think when Mills brought this objection to Henry, Mills's colleagues on the Jeffersonian Republican side must have been livid. They were being cast in the role of religious inquisitors. This was not in line with Jeffersonian thinking. And I think the Federalists must have been pretty unhappy with this proceeding also. The regularity of elections was not something that should be overcome on a basis that was less than really clear in the North Carolina Constitution. The North Carolina Constitution really wasn't all that clear on this point. Too many historians, I would suggest, have used the Henry episode to look for a usable, workable past. They wanted it to fit into a narrative of the rising or the new tolerance, or the fact that the alternative view that North Carolina in 1809, as illustrated by the Henry event, was a particularly intolerant place. And I think that what we really may be seeing with the Henry motion is an incident more related to oddity and very odd people. I don't think Mills was in line with the zeitgeist of his party or the particular his colleagues in the legislature, and I think that's one reason he disappeared from political life. There's another part I'm going to present more closely related to the oath, but I'll simply, one point I want to get across is this was the first paper I wrote, what I've just discussed, which was the debate involving Henry. And I just want to mention a few things that I sort of learned on the way by investigating this matter that don't relate exactly to the motion, but relate to broader North Carolina history. Just about everyone who participated in the Henry motion or participated in debate or held a high position like the Speaker or the General Love was either in the militia or in the US military at some point. Everyone who participated was in the military. And another thing I learned investigating this is that older people at this time, when they retired, sold their goods or gave them to their family and often moved to the Western frontier and would set up a new life for themselves. And this is a repeated pattern you see with many of the characters in the Henry motion, where, for example, General Thomas Love and the Speaker of the Clerk of the House, Pleasant Henderson, all these people towards the end of their life left North Carolina and went west. I mean, it's just hard to believe that these older people were living on the frontier, but that's exactly what they did. And it was also a deeply militarized society. Any number of the people involved in the Henry motion not only were in the military or the militia, but held high office. There are generals and lieutenant colonels and majors and captains. There's one who was just a soldier, a common soldier, and that was the exception. So that I have to say surprised me. And another thing that surprised me is that it is not widely reported that that Henry not only prevailed, but he substantially prevailed. It looks like he prevailed unanimously. And that was one thing I learned about the Henry motion. But there are still some oddities, and I realized this after writing the first paper. One of the oddities is we still have to explain, why did Henry disappear from American political life? Why was there no even obituary? Why were there no records Why didn't any newspapers or any books report he passed away in 1847 and report on what he had accomplished during his life? Because certainly thereafter, he certainly is remembered, at least as a squib or an occasional footnote in American history. And the other issue is the oath. And part of Mills's objection seems to have been that Henry did not take the oath of office, or the proper legislative oath when he was sworn in. Other people have understood Mill's objection is that he didn't take it at all, or that he didn't take it while holding a Bible, particularly a Christian Bible. Again, this goes back to the fact that Mills used very abstract language, but historians and other commentators seem to have very specific views about what Mills meant. Or not only that, they seem to be taking at face value the truth of Mills's objection, even though nothing was proven or illustrated or shown when the matter went to the committee of the whole. That is, what's the documentary evidence that Henry didn't take the oath? What's the documentary evidence that Henry couldn't have taken the oath? And again, one of the greatest oddity with these early commentators and even modern commentators is that even though there are so many of them, none of them take the time to actually reproduce what that oath was that they allege Henry either didn't take properly, or took while holding a Christian Bible, a Jewish Bible. That is, the allegation, according to some, is that Henry's oath was seen as invalid, or at least seen as invalid by Mills, because he wasn't holding a Christian Bible. So I thought this question should be re-examined too, and that became my second paper, the one that was in the American Journal of Legal History. And the question is, where do you find the oath? And part of the confusion here is that many people look to Article 32 to understand the oath. Article 32 is a religious test. It denies people the ability to hold certain positions, offices, or places of trust, it says, if they deny the truth of the Protestant religion and a few other principles or a few other contestable views. But it doesn't actually set an oath. The oath requirement in the 1776 Constitution is actually found in Article 12. And that article mandates that there shall be an oath, but Article 12 actually doesn't set the terms of the oath. The actual content of the oath was left to the state legislature after North Carolina declared its independence to set the terms under the new Constitution. And that's not so surprising. That's exactly the way it was in the US Constitution. In the US Constitution, Article 6 says there shall be an oath for officers and for members of Congress, but it left it to the first Congress to enact that oath requirement. As a matter of fact, the first statute that the US Congress passed when it first met was to create an oath for the legislature and for office holders. So my job for the second paper was to recreate or refine or rediscover the oath that was in force in 1809. So one thing I knew from just general history is that pre-independence in England and in England's colonies, there were oaths. And not only that, but many of these oaths were expressly Christological, and many of these oaths would end with the phrase, upon the true faith of a Christian. And certainly those oaths would be troublesome for a Jewish person to take, and maybe prevented a Jewish person from taking. But in fact, those oaths are not all that ancient. They only go back to James I. Probably an oath like that was enforced pre-independence in North Carolina. But my research started post-independence. So the first post-independence statute dealing with oaths was passed by the first legislature that met in North Carolina, the first session in 1777. And that was just a general act called an Act Concerning Oaths. And that act, called an Act Concerning Oaths, wasn't specifically there to meet the command of Articles 32 and Article 12. It was just there to create an oath for the new court system post-independence. And that oath did have Christological references. But interestingly enough, it had opt-outs. And it said for people who were conscientiously scrupulous of taking the standard oath, an alternate oath was provided for them. That oath also had religious references. It referred to a solemn appeal to the supreme God, but it wasn't expressly Christological. And a Christian could take it, a Protestant could take it, but I would suggest probably a Jewish person could take that oath too. I know I'd certainly be comfortable taking that oath. But that was not the oath that members would take. That was just a general judicial oath or a general oath a general oath to be applied in North Carolina. Then in the second session of the 1777 legislature, another act was passed, and this was called an Act for Ascertaining the Oath of Allegiance. And this one was expressly created for Article 12 purposes. This was the first such one. It applied to members of the legislature and it applied to officers of the North Carolina government separately. It was entirely political. It was there to, it mandated that people taking the oath accept political principles, which is basically to abjure, to deny the powers of the king of what was called the King of Great Britain in the statute, and of the English Parliament, or I should say the British Parliament. It was an oath to North Carolina and to the principles of the Revolution, and there was no express Christological content. As a matter of fact, it didn't end with the traditional for British Parliament language of upon the true faith of a Christian. It ended with the language, "So help me God," and there was no command to hold either a Christian Bible or any other book. So this first oath that was passed by the legislature was pretty broad. It didn't have any express Christological language. It was for members of the legislature. If this was the oath that was in force at the time of Henry, it's hard to see why he'd have any trouble taking it. In fact, it ends with the language, "So help me God." So it did have a religious element, but it's important to understand here, there was no demand that the person accept any defined set of religious principles. What the person had to accept were political principles or principles related to loyalty to the new revolutionary state in South Carolina. So it ended with "So help me God." It was theistic, but that was really there to test a person's sincerity. It wasn't really there to test their religious principles. And even if it were, it wasn't in any way obviously offensive to Jewish sensibilities. The next act that was passed was in 1791. And I think my research has shown that this was the act that was in fact in force in 1809. This was called an Act for Altering the Oath of Allegiance. It altered the prior one that I just described from the second session in 1777. And the reason the new act was needed is between 1777 and 1791, the new US Constitution came into effect, and the US Constitution mandated that all state officials, including members of the state legislatures, take an oath to the federal Constitution. So the state oath had to be modified to incorporate the new federal Constitution, which is exactly what this did. Under this new act, state officers and members of the legislature had to take an oath. The language of abjuring the king and parliament was now gotten rid of. It was considered long after the revolution. And this new oath that was created for members of the state legislature and for officers, it didn't have any Christological references. It was just an oath to the state and one to the federal government, the new national government. It was also, interestingly, an anti-bribery and an anti-conflict oath. It didn't end with upon the true faith of the Christian language. Once again, it ended with "So help me God." So what we have here is a statute that tested political principles and loyalty to the state, not religion per se. It's true it ended with "So help me God," but this wasn't an express reference to any particular religion as it would have been understood at that time. Apparently this was in force in 1809. There was no command to hold up the Christian Bible or any other book. It was at best, or perhaps I should say at worst, theistic, but there was no religious test in the customary sense of the word. It was just a test of sincerity when it used "So help me God" language. It wasn't testing religious principles. It's very difficult to see why Henry, if he was Jewish, assuming he was Jewish, would have had any Jewish-related objections to taking this oath. And since there's nothing in the oath that required Henry to hold a Christian Bible, if he held a Jewish one, it's hard to see why that would be objectionable. That is, If what Henry did that day on November 20th, 1809, was to take the oath in the standard way, holding a Jewish Bible, one would expect that Henry's defense might have simply been, I was obedient to the statute. The reason you shouldn't object to my being a member is I did what the statute required. So the puzzle with Henry and his oath and the objection to Henry and his oath is that there's nothing in the oath that on Jewish sensibilities, at least as I understand them, both today and at that time, would have been offensive to Henry. And Henry, if he wanted, could have held a Jewish Bible, and that wouldn't have been contrary to the rule. So the question becomes is, if he obeyed the statute, why didn't he build his defense around the statute and simply say, this is what I've done, and it complied with the rule? And that brings me to an alternate theory of what happened with Henry. It's a little bit controversial, but I think the problem with Henry and what led to the objection involving Henry's oath might have been not that Henry held a Jewish Bible, but that Henry held a Christian one. And the objection that Mills had was that the way Henry took the oath was, in fact, according to sensibilities at that time, sort of fraudulent. That is, Henry wasn't holding a book that was indicative of his sincerity because he wasn't a Christian. And that might explain why Henry never testified. Because if Henry testified, then he would have said, yeah, I took the standard oath, but I held a Bible that didn't mean anything to me. And that probably would not have gone over very well with the other members. And I don't think it would have gone over very well with his constituents. Let me put it to you a different way. If Henry had taken the oath on the Jewish Bible, then at worst, the result should have been, the way these rules are usually applied, is that even if the legislature said Henry made a mistake, he should have been allowed to take the oath again without any Bible at all. The problem was the way he did take it, I suggest, was one that they couldn't let him take it again, because to them, it might not have looked like it was good faith error. And that might be the oddity of the Henry story, that it in fact might have been just the opposite of the way the standard narrative's usually told. The Henry story is not a story of fighting over deep principles or principles of religious toleration. Those were ad hoc explanations after the fact. The story of Jacob Henry is something like the story of Michael Glindor, about which a movie just came out several days ago. There's a movie called Operation Mincemeat, which is itself a remake of a movie from 1956 called The Man Who Never Was. It was about a man who served in the British Armed Forces only as a dead body, but he was believed to be somebody else. And I think that's really what happened with Henry. Henry is a man, I think, who just made a mistake, and then ultimately came in the popular mind to stand for principles that he might not have ever really stood for during his life. But they were certainly principles he found himself defending while launching his own defense. It's an odd story, but I don't think it's a story that's really essentially about the intolerance of North Carolina in 1809, or 1809 North Carolina becoming more tolerant, as indicated by the way they voted. I think it's a story of accident and mistake, and people being a little bit embarrassed about what they did and how they came to do the things they did them, and trying to cover them up a little bit. And I think that's why Henry didn't testify. I think he was a little bit embarrassed about what he did. And I'm not surprised his political life really ended, to tell you the truth at that point. I think the people who knew what Henry did probably encouraged him to leave the political scene. And I think he knew himself that he didn't want this stuff to be well known. And it was better that his political speech was probably the thing he was remembered for in his own mind. So anyway, it's a different telling of the Jacob Henry story. I think it is borne out by the facts that we know. It's not a story of light or darkness, but perhaps it's a story about how average people deal and sometimes solve the tricky situations they find themselves in. Anyway, I'm open to questions.
Yes. Thank you so much, Seth. You've given us a lot to think about. If you all have questions, if you wouldn't mind typing them in the chat, and then I can ask. I have one to start us off. So you touched on this a little bit. You're talking about his legacy and how his legacy was interpreted by different historians over time. So I guess with your work, and you kind of touched on this in your summation just now, but with your work, where do you see Henry's legacy going now? Like what should we do with him moving forward?
Well, I don't think everyone has to be George Washington or Abraham Lincoln. And if Jacob Henry isn't George Washington or Abraham Lincoln, I'm not going to lose any sleep. Um, I think it says something very positive, to tell you the truth, that Henry, given the situation he found himself in, um, not only defended himself, but that the wider debate that took place in the legislature and then wider society was very highbrow. That is, to me, one of the most interesting things, particularly speaking as a lawyer, is that on one day's notice, the arguments that were made in the legislature were really very solid, very erudite legal arguments. And people were trying to argue principle over anything low-spirited or mean or shallow. And the fact that Henry came to stand for something probably that was bigger than he ever intended to, I think is something to sort of be celebrated, even if we can't celebrate Jacob Henry the person, which is sort of the story of Glyndŵr Michael, who, you know, he was a Welsh tramp who died of rat poisoning, who basically in death saved 100,000 people or so in World War II. Henry came to stand for, you know, today what we think of as core principles of American religious freedom. Maybe undeservedly so, but so what? That only makes it a better story.
Okay. Well, we have a couple questions in the chat. So to start us off, Michael Hardy commented that we could use a good history of the General Assembly and Supreme Court in North Carolina. I would agree with that. We don't have a lot of compiled histories of those two things. Usually, if I'm researching history on either the Supreme Court or the legislature, I go to the North Carolina digital collections. So that's digital.ncdcr.gov. And that's hosted by the archives, and they have curated collections that deal with the Supreme Court and with the legislature. But yes, I agree.
I don't know of any good history of the legislature, but I try to cite a few stories of a few histories of the early history of the court system in North Carolina, and it is not an easy history to understand because titles were changing and the names of the courts were changing in the antebellum period, and it is a little confusing, and people's titles were changing too. So I agree with that. I know I was confused by it when I wrote this.
Yes, absolutely. And then, so we kind of have two questions that touch on the same thing. So after Mr. Henry's brief service, how many years elapsed before another person who identified as Jewish won election to a seat in the North Carolina state legislature? So
that I certainly don't know. And we might not ever know that, because it may be that there was a Jewish person who just didn't want everyone to know he was Jewish, or didn't think it was a matter of public information. I think sensibilities with regard to religion might have been a little bit different then, to tell you the truth. You know, not everyone wears their religion on their sleeve. To tell you the truth, that's certainly true now, but I think it might have been also true then. And also organized Jewish life in this period of American history. It was not very organized.
Mm.
And identities probably were more fluid than we're used to today in the United States.
Okay. We're also joined by Dr. Leonard Rogoff, and I
Oh, hello, Len.
wondered if Leonard, I wondered if you knew if who the second identified or the first verifiable Jewish person serving in our legislature. Do you know that name?
No, I suspect that there was a man, either his name was Lipman Aaron or Aaron Lipman, who served in the 1840s for one term. I was Jewish, as there is a peddler identified in credit reports as being Jewish by that name at that time. And we also know, even in terms of the qualification of officer, that Michael Grousman, who served as a kind of lay rabbi in Raleigh in the 1850s, was employed by the executive, by the Treasury Department. And even so, and we also know Jews serving in the 1860s as city councilmen. So apparently it was honored in the breach.
Okay. Well, the second half of that question, if we're talking about who was the first verifiable Jewish person serving in these, positions of elected power, what does their story tell us about North Carolina history? So I guess what does their time of election tell us about what's going on in North Carolina?
Well, I'm not 100%. I'm sure I understand that question. Part of the problem is that the language of Article 32 is, to be perfectly blunt, opaque. It's not exactly clear what the scope of that language is and what positions are meant to fall under it. And again, I tell this, just to be clear, I came at this wondering if that language extended to the legislature at all. And there were a few people back in 1809 who simply argued it didn't. That is, the legislature was exempt from this requirement. I wouldn't be at all surprised if municipal offices weren't covered by it, or at least some people believe that those people didn't have state office, they had local or municipal office. It's contestable, we simply don't know. And there's some reason to think it might have not included the governorship. As a matter of fact, there are some people who lay claim to the fact that it was a Catholic governor who would have been out of the orbit of this. And the question is it because he either wasn't known to be Catholic, they didn't enforce it, or because it was understood that it didn't apply to elected office at all? So again, we don't know that there was any central core widely held meaning. It wouldn't surprise me if it was under enforced. Certainly Gaston was a Catholic. He served on the Supreme Court of the state of North Carolina. There doesn't seem to be any unhappy litigant who tried to get him thrown off. That could be explained many ways. One way it could be explained is that Article 32 was not understood to apply to apex positions. I can't prove that, but we do know that Gaston was Catholic. This was publicly known. And one would think that there might have been an unhappy litigant over the years he was on the Supreme Court who would have tried to have him removed. But apparently there wasn't one. So maybe it's, as Leonard said, it was honored in the breach, but maybe it was also understood that if you go out to cut someone out of political office and you lose, you're not only losing, but you're illustrating you don't really understand your own constitutional system, which could prove very embarrassing. Maybe that's one reason Mills disappeared, because if you aim for the king and don't kill him, you lose. And perhaps that's one reason Mills disappeared from his political career thereafter.
Okay. This next question is from Leonard. If the issue of religious tolerance was not a factor in the Henry case, how does one explain the subsequent history of the religious test? He goes on to say, in 1823, a state constitutional convention dismissed a call to expunge the test as not relevant. In 1835, when legislators recommended its abolition, the convention voted to change it from Protestant to Christian, and the arguments were highly sectarian.
Well, I'm not going to say religious motivations weren't at play once Mills objected. My inquiry is really slightly different. Certainly the arguments that were made in front of the legislature, in front of the committee of the whole, were in part Henry's arguments that were related to religious freedom. And the Article 32 was subsequently amended until finally in 1868 it was expanded and Jews weren't precluded. But even to this day, there is a successor to Article 32 in the North Carolina Constitution, and it doesn't incorporate atheists. And there are atheists in North Carolina who feel cut out. So the issue is not one that led to an obvious conclusion that was entirely religious neutral. And I certainly don't want to be understood as saying religion and religious understandings didn't play a role. What I'm trying to add is I don't think that was ever Henry's intent. I don't think Henry was ever making a political statement by holding a Jewish Bible. As a matter of fact, I don't think he was holding a Jewish Bible. I think probably what he was holding was a Christian Bible. And he was embarrassed by the fact, and that's why he couldn't testify that he was in fact obedient to the statute. If he had held a Jewish Bible, it might be his contemporaries would have been happy enough that there would have been no objection. So what I'm suggesting is the Henry story isn't a story of an intolerant legislature finally vindicating principles of toleration. It was more likely, I think, a history of mistake, accident, caprice, and embarrassment, where the embarrassed party tried to get out from under by preaching principles of religious toleration. And I'm not saying that's why he won either. I don't think it was his speech of religious toleration, which in fact convinced the legislature, any more than I think was the office argument. I think what happened is that the members of the legislature were deeply uncomfortable under wider American norms and understandings of what a legislature should do with a regularly elected member. And they were looking for any reason to get out from under and not to enforce Article 32. And once they heard the testimony and no one actually saw what he did that day with any clarity, and the people who did claim they see what Henry had done were giving conflicting testimony, the legislature simply said, we don't have enough evidence to deny him his seat to which he was otherwise duly elected, and just kicked the whole matter overboard. And again, they weren't trying to uphold matters of religious freedom. They were themselves trying to get out from under. This was a very difficult position for the members to be in. And the absence of evidence, I just think, made their life much easier. And why should we be surprised that it was unanimous at that point, as opposed to a partisan dispute between Jeffersonians and Federalists? After all, one would think if the Jeffersonians really meant any of their traditional principles were the advanced progressive principles that we tend to value today in modern liberal life, they couldn't have been happy with Mills for bringing this objection. As a matter of fact, I think, quite frankly, they were livid and were looking for any way to sweep this under the carpet. I don't think the Federalists were happy with Henry either. I think the Federalists were probably looking at Henry the whole time and saying, why didn't you just swear on no book at all? Or why did you just swear to Jewish Bible? Why have you created so many problems for us? And I am not a bit surprised that 1809 was basically the last we heard of either Henry or Mills. I don't think either of them had a friend in the legislature after this event, because they had done nothing but create problems over an issue that should have never been politicized. But once the issue had been opened up, people reached for what political principles they thought would do well in the public realm, both on the legislative floor and in wider North Carolinian and American society. But I don't think that was the plan.
Okay. We want to be respectful of everybody's time, but we do have one further question. It's, since Henry was not from the area around Raleigh, do we know if he had any contact with the Mordecai family, which was a local Jewish family?
I can't answer that. I really don't know. I know there was a Mordecai who later ran for I believe it was Attorney General of the state. I reference it in one of my footnotes. And that was certainly a statewide office that Article 32 would have applied to. I wouldn't be at all surprised if Henry knew these other people, particularly if Henry was Jewish, as I suspect he was. But as I said, we don't really have a lot proving that. And I think in part because, although North Carolina wasn't the frontier, certainly for Jewish life, North Carolina was the frontier in 1809. And identities were probably fairly slippery in that sense back then.
Okay. Does
Okay.
anyone have any further questions or anything? Please just put them in the chat. We just have some folks saying thank you. Great program. Thank you so much for joining us, everyone.
Thank you too.
If you need to ask a question, we'll hang out for just a few more moments. But again, thank you everyone for joining us this evening. Seth, you've given us so much.
Well, I have a question. I want to know if I convinced Len Rogoff. That's my question.
Yes.
I'm glad to hear it.
You know, I very much enjoyed it. It was really informed. I mean, I think you're right. I mean, about the fluidity of identity back then. And for example, the most notable prominent Jew in Wilmington, who's a contemporary of Henry's, Aaron Lazarus, kept membership both in St. James Episcopal Church in Wilmington and the Beth Elohim Synagogue in Charleston, and said, I can worship God in whatever temple he appears.
And was he of Sephardic descent?
Yes, he was a Sephardic Jew
that attitude might be a leftover from the expulsion from Spain.
Well, and also we do know whatever Jacob Henry's stepfather, Joel Henry, State Archives does have his will, and he signs it in Hebrew and dates it in Hebrew as Yoel, Ben Rav Hirsch Eiger, the Joel, the son of Rabbi Hirsch Eiger. So that I think would be a pretty definitive statement, at least of Jewish origins of his father or stepfather.
Absolutely, and that's telling if we're exclusively focused on what you might call the ethnic or the religious component. But if instead we're looking at what I think most historians are interested in, which is how did Henry view himself in his own mind subjectively? I think the answer to that is we really don't know.
I mean, the religion he expressed is just a very common 18th century Enlightenment deism. And he's using the same arguments that you hear in Jewish emancipation internationally. There are arguments that are made by Moses Mendelssohn in Germany about the entitlement of Jews as citizens of the state and the compatibility of the Jewish religion to Enlightenment ethics. Okay, I'm sorry.
It's okay. All right. Well, I asked the important question, and if there's no one else in the chat, I'll simply say thank you. But I'm willing to hear another question if there is one. Karen?
No, it looks like that's all. But we do still have just folks saying thank you. Thank you for arranging this informative talk on a lesser known yet symbolically important historical figure. Yeah. So I echo that. Thank you so much for joining us, Seth, and thank you for staying
sorry
up.
I went so much over the 20 minutes we had talked about.
No, that's perfect. Thank you for joining us so late as well. Thanks for staying up late to join us.
Okay.
All right.
Okay.
Thank you, everyone. I hope you have a good night.